Please, Lordship. Lordship, I beg to mention hearing item number 10, Lordship. I pray for a week's time, Lordship, in this matter, for filing of written argument. For filing of written argument, Lordship.
Lecturers,
Yes.
expert member. Have the other parties filed their?
Nobody has filed, Lordship.
I am filing it today, my lord. It's ready. It's in the file, my lord.
Exponent 3 to 5 also, I'm filing today, Lordship. Myself, I've started. It's almost completed. I'll file it in a week.
My lord, I'm filing it right now, my lord. The copy.
Let the matter be called up then.
My lord.
Let it be called up.
Daily list item number 1.
May I please, Lordship. Lordship, this is a second round of bail application, Lordship. First round of bail application was rejected, Lordship, by order dated 12/6/2024, Lordship. On the stage that that is for recording evidence, Lordship, and the deposition of the survivor to be recorded on 12/6/2024, Lordship. Lordship, there is an order, Lordship, in 75, page number 75, Lordship, of this honorable court, Lordship. Yes, Lordship. At serial number 10, Lordship. It is also submission of the parties that the stage of the case is for recording of evidence, and the deposition of the survivor is to be recorded today, that is 12/6/2024, Lordship. So, Lordship, it has been more than 3 months, Lordship, ever since the rejection of my bail, Lordship. None of the witnesses have been examined, Lordship. So, several dates were fixed, Lordship, but
Just a moment. This is a bail POCSO matter, no?
yes, Lordship.
Then you have to take step for issue of notice.
Yes, Lordship.
You do
What
that.
I'm praying for is to issue notice, Lordship.
And Mr. Shulai,
Lordship,
can you get the status report?
Lordship, kindly see, Your Lordship, at page 74, para 9, Lordship. The earlier bill application, Your Lordship, had been rejected on merits, Your Lordship. Lordship, Lordship was pleased after going through the case diary, Your Lordship, and considering the fact that the manner in which the survivor was subjected, Your Lordship, to brutal assault, Your Lordship, was pleased to reject the bail. The para 9, Lordship, there is a clear finding, Your Lordship. So there is no scope, Your Lordship.
What
for
is the change of circumstances
a
then?
change of circumstances? What are the change of circumstances, Your Lordship?
But we still have to be mindful of section 35.
Lordship, Your Lordship, what,
If-
Lordship,
If even
that
after this date, in spite of the observation made by this court,
it's true, Your Lordship, but
no witnesses have been examined.
Lordship, that is the submission, Your Lordship. But we do not know, Your Lordship, who is at fault, Your Lordship, whether the prosecution is at fault or the accused is at fault, because there is nothing on record, Your Lordship, to show that.
You get the status report then.
Lordship is.
In the meantime, you
Notice will be issued, Lordship.
what Mr. the counsel for the petitioner. At the outset, the London counsel, while moving this petition, has submitted that he will be allowed to take steps for issue of notice upon the respondent number 2, who is the complainant, who has filed the. He is the one who has filed the FIR.
Yes, Lordship.
Respondent 2 is the one who has filed the FIR.
Yes, Lordship. He's the complainant, Lordship.
Who has filed the FIR.
Informant.
Has filed the FIR. Mr. Indishulai, London AAG, appearing for the respondent number 1, has submitted that he may be allowed to file the status report as far as the progress of proceeding before the trial court is concerned. On premiere, this is matter up to 2 weeks.
Apply, Your Lordship.
Item number 2.
Your Lordship, as per the last order passed on 25/7/2024, Your Lordship will see paragraph 5. Of the last order. No?
Yes.
In the course of hearing, the Learned Standing Counsel has pointed out that the petitioner, by representation dated so-and-so, had approached the Chief Executive Member KHDC with a request to relook and verify the order of the Executive Committee of the KHDC dated so-and-so. As regards the villages, namely so-and-so, a copy of the same has been annexed as Annexure 13 to this petition. In response thereto, the District Council had issued notice dated so-and-so for the purpose of meeting the parties concerned, including the petitioner, to sort out the issues involved. However, in the meantime, without awaiting the outcome of the said proceeding, the petitioner has now approached this court, which, according to the Learned Standing Counsel for the respondents, is premature and has prevented the KHDC to proceed further in the matter. Has, however, submitted that there will be no objection on the part of the petitioner if the KHDC proceeds with the disposal of the said representation so-and-so. Accordingly, on submission so made, this court in the interim would allow the respondent KHDC to take up the said representation dated 21/6/2023 and to dispose of the matter in accordance with law. The decision made by the KHDC in this regard will not prejudice any of the parties if this writ petition proceeds for final disposal. Now, what has happened, my lord, the KHDC has taken up the matter, but your lordship will see there are other connected matters also. That is from serial number 4, 5, 6, 7, 8 and 9.
So they are
cause list.
They are not identical.
No, they're identical. In fact, the order was passed only on item number 2. These are identical, my lord.
Your Lordship, regarding WPC 190, we have filed an appeal before. We have filed an appeal because, Lordship, in the we are not a party in WPC 426, Lordship. And what happened, Lordship?
You file appeal?
Had filed an appeal only in the ground that the order was passed only in WPC number 426 of 2003.
Moreover, Lordship, instead of disposing the representation, Lordship, they have issued notice to us to submit written argument, Lordship, which start to again open the proceeding, Lordship.
I don't understand.
My lord will come. We will see number 4, item number 4. My lordship will come to item number 4. That is WPC number 185 of 2024.
Yes.
And your lordship will come to page 96, Annexure 12. Now, this is the same representation which was filed before the KHDC by the Sardar.
96.
Annexure 12, page 96.
Here it's not 96.
WPC 18. In this case.
Page number 116. 116, my lord. Annexure 12.
Yes, 116.
The same representation.
116.
116.
Lordship, they have written one representation challenging 7 orders, Lordship.
No, what happened, my lord, when they had initially filed the writ petition, only one writ petition was filed. Although it was a common order, orders were passed in 7 different, because there are 7 different villages, so different orders were passed. So when they objected, then the petitioner filed 6 more writ petitions, challenging the same order. The subject matter is the same.
Parties are different.
Only the
The
parties.
respondents are
Yes.
Evidence
Yes.
So it would be against a individual
Yes.
villages, so to say.
Yes.
Now what happened? Single representation, Your Lordship. Now do you want to take up a single representation altogether? Altogether the 7 villages. That altogether.
So that is between the petitioner and the district council.
Yes.
Yes, Your Lordship.
How
Now,
they?
you, as far as you are concerned, you can intervene, or you are a party, and you have to agitate the matter before the district council.
In fact, we have called them. They have objected before the district council, saying we are not parties to this writ petition. So that's where the.
As far as the writ petition is concerned, you see, you are not concerned with it. What is material is on the basis of this petition filed by the petitioner before the district council. You have been made party.
We have also filed a show cause.
So then
We have filed the objection.
My Lord's order.
Can we proceed with this?
you can proceed.
Yes.
Well, not necessarily here,
Yes.
because here you are not a party.
We are a party, Your Lordship.
You are a party.
Yes, sir. That's
My
why
Lord, may I just explain?
Now the main issue.
So okay, even so, it makes no difference, because this court, as Mr. Dingdo had pointed out, had given the liberty to the district council to proceed with any representation filed by the petitioner. So that will, in fact, you might consider it a parallel proceeding. It will go on its own. It will proceed on its own, and this matter will also be taken up. If at some point of time there is some overlap, at some point of time there is some, conflict, then the matter will be looked into. So as far as your right is concerned, you've been made a party in both forums. So I don't think you have any grievance at this point of time.
My Lord, he is already a party since the Special Council explained. Now, 7 villages came up before the Executive Committee seeking for recognition or creation of new village. And District Council took the matter, issued notice to all the parties, including me, and passed an order. Now, when they issued the impugned order, we got the impression that only single impugned order was issued. Therefore, we challenged that single impugned order before this court, after filing a common representation before the District Council. Now, my friend came up with the application to strike off that no, there are not only a single impugned order, separate order has been passed, and he is not impugning that one. So, Lordship struck out their name, allow me to file a fresh writ petition. Instantly, I filed a second 6th writ petition, which is tagged together. It listed all throughout together. Now, in the last occasion, Senior has read out. On that, the matter was listed, and Senior has pointed out that there was a common representation after passing the impugned order by District Council. Common representation was put up by the petitioner. Now, without awaiting the outcome of that one, he has filed a writ petition. So it appears to be premature. In view of that backdrop, my Lordship allowed the District Council to consider representation parallelly. My Lord, my friend was present very much. He is the counsel for all the 7 villages. He has no objection. It was a common order. Only my Lord passed that order in the today's item number 2. It was supposed to be reflected in the same order in other subsequent writ petition also, but since parties are in consent, Lordship order reflected in only one writ petition, first writ petition. Now what they have done, to delay the matter, they filed a writ appeal. And the matter came up, and the Honorable Acting Chief recused himself, since writ petition also he recused himself. So that is still pending. Now, District Council assists the matter, and Lordship give liberty District Council. Me, including me and my friend, they can go and appear, and District Council will pass appropriate order. If I find aggrieved, I may challenge. If I find aggrieved, they may challenge. That was the substance of my Lordship order, allowing District Council to look in that representation. So he cannot say that I am not the party. Behind me, the Lordship has passed order. That is
I think now it's clear. He has agreed. He has agreed to participate in the proceeding for the District Council, as well as in this court. Now, what is the stage of the proceedings for the District Council?
No, it's nearly the only problem, my Lord, is they came up with a petition and say we are not a party. So the District Council also is stuck, because they say that these 4, 5, 6, 7, 8 and 9 are still pending before this court, and no order has been passed in those writ petition. That is the problem with the District Council. So if the same order is passed in the 4, 5, 6, 7 and 8 and 9, which are listed today also, the problem will be solved.
Yes.
And the District Council can go ahead and decide the issue now.
See, more often than not, it is implied
Yes.
that when an order is passed in a single petition, which invariably covers others,
Yes.
similarly situated. It is so. I mean, that's the impression the court gets. So therefore, you see, the order would say on premier party, this is matter.
Yes.
Now what happened also now? This council should do separate hearing for 7 villages.
That we'll see. We'll take care of that. We'll take care of that.
They do separate.
That you see, that would be your prayer before the district council, and let them take a call on that.
Yes.
As far as the individual villages are concerned, they may have separate issues, separate points of contention. That's a different matter altogether.
Now, Your Lordship,
In fact, the district council is trying to work out a formula to find a consensus. That's what we are trying to do.
So at this point of time, what is to be done? So we'll have to
Lordship may just clarify.
just
Clarify
clarify
order passed by
that this
earlier
order is also
is
made
covered to
applicable
others.
in all the other.
In all the other,
In all that.
in item number 4, 5,
That would
6.
do, Mr. Kriam.
but Your Lordship, one problem in WPC 190, we have filed an appeal because Your Lordship,
Appeal they can withdraw because appeal has not been taken up also.
Yes.
If you file an appeal, then there's no notice,
No.
no stay
because-
order, nothing.
No,
No
no
notice
order.
issue.
Your Lordship, can this matter come after 1 week because senior counsel Kipol is leading in this case, Your Lordship, I have to observe it. Only 1 week.
Yes, as Mr. Dingdo has suggested,
Yes, Your Lordship, let me.
you can withdraw that and proceed. Otherwise, there will be a
It's only in one, I think, in one writ petition. It can apply to the others.
Right.
Only
Only
in
1 week, Lordship, let me see instruction book senior because it's leading in this case, Lordship. But I think only 1 week. Then.
where is that order dated?
25/7. 24 in WPC number 426 of 2023.
This was the first item that was listed.
Yes.
Yes.
Heard Mr. T.T. Dingdo, learned senior counsel, who is also the standing counsel of the respondent KCDC, who has submitted that this court on the strength of this court's order dated 25/7/2024, passed in WPC 426 of 2023, the respondent KHDC had taken up the proceedings in as far as the as regard the representation filed by the petitioner herein. It is also the submission of the learned senior counsel, a standing counsel, that the petitioner had filed a composite representation arraying as many as 7 respondents,
Well, 7 villages.
7 villages.
7 villages as respondents. Incidentally, all the said villages are also respective respondents in separate petition filed by the petitioner pending before this court on the same subject matter, dealing with the same subject matter. the Mr. Ikram letter counsel appearing for the respondent number. Your respondent number 4 has, however, submitted that he is also representing other similarly situated respondents in the other writ petition, but since no specific order has been passed by this court as far as the participation of the said respondent in the proceedings for this council, therefore some confusion has arisen as to the actual role and participation of the said respondent concerned. To simplify the matter, the learned counsel across the board has submitted that this order, that is the order dated 25/7/2024 supra, may be also made applicable in all to all the related writ petitions filed for this court. Namely,
We will give the we will give the numbers. The 4, 5, 6, 7, 8, and 9. No, we list today.
Accordingly, on the consent made by the parties herein, this court would hereby extend the application of the said order dated 25/7/2024 supra to all the related writ petition as aforementioned. Will that do? In the meantime, it is reiterated that the parties are at liberty to join proceedings as far as the matter pending before the council is concerned. This order will be applicable only to those orders except the one which we have filed in appeal.
Except in item number 9. Item number 9.
Item number 9 pass on separate order. List this matter after 1 week.
For in all the matters, for respondent number 4, affidavit will be filed after the proceeding for me to file the counter, because I have to bring on record all. If I file now, then
Mr. Friam Ashwa has also submitted that he may be allowed to file the counter affidavit
for respondent number 4 and all the
on behalf of respondent number 4 in due course.
after the
We'll see. Not after the. We'll see. We do know. We'll see what will be the fate.
Well, not only
If that is the case, then you see, if we have to wait for the proceeding for this council, then it will be.
yes.
No, we don't know when it will.
if I file now, then all those
They don't need to file now.
subsequent development I cannot bring on record.
That you can come and you see at the relevant point of time, you can come with the additional affidavit.
Okay.
Only my lord.
Yes, it would be, as Mr. Dindo has pointed out, it would be proper for the parties if they can settle the matter
Yes,
amicably,
that's what we are trying.
and then that'll be good for all.
Yes.
My lord may even reflect my submission that the lordship order is applicable even to the item number 8.
4, 5, 6, 7, and 8.
My friend has made submission that today's order, lordship order, will not be applicable to the one he has filed appeal.
Yes.
In fact, my prayer is that, my lord, that
Do I just
lordship
make a
order is even applicable to that writ petition.
we just inform the court that we have filed appeal only on 190.
Appeal is a notice not issued, not taken
Just
up.
inform the court that we have filed appeal.
It applies to all the
See,
requisitions.
since you have informed the court, so now I have to take judicial notice of that. Now I cannot pass a contra order, except as it's up to you. If you wish to withdraw the appeal,
Yes,
then
yes, yes.
the matter we are back to square one.
I'll seek instruction on that. To withdraw.
So as far as that
Only number
matter is
9.
concerned, we'll list the matter after 1 week for you to get instruction.
The others may
The others?
3 weeks.
3 weeks. Okay.
Much obliged.
Item number 3.
Over to you.
May I please, Your Lordship? Yeah, my Lord, the confusion was whether the accused person, after the bail was granted, my Lord, whether he has appeared before the IO or not, my Lord. In one document that I have shown, my Lord, it was not put the date, my Lord. This is the document, my Lord. This is the original document where the IO has put a date. 2 documents was made signed, my Lord. The date was not sent to us, my Lord. The accused has hold by himself, my Lord. And this is the document. And I have supplied a copy to them also, my Lord.
If I may, my lord, I've inquired from the IO. If my lord may recall, the status report dated 4th of September showed that the accused has not appeared. I again inquired from the IO. He said the accused has not appeared personally before him or at the police station. It was his friend who handed over these documents to the IO. Therefore, my lord, the petitioner is blatantly trying to mislead this honorable court, and therefore I'm strongly objecting to the bail. One of the conditions of granting interim bail was that he shall appear before the IO, which has not only been not complied with, but the petitioner, the accused, has chosen to blatantly mislead this honorable court, and therefore doesn't deserve any sympathy.
Yes, Mr. D, if that is the case.
No, my Lord, that is not correct, my Lord. If my Lord may kindly read the content of the letter that was addressed to the IO, I, subject and all, my Lord, I am Gopal Kishan Gaur, so and so, dated so and so, so and so, I present before you. My Lord may kindly see the letter, my Lord, which has been addressed and which has been handed over to the IO, my Lord. What I have been instructed, my Lord, that he has.
Why
appeared,
would you see, if you say you have appeared for him, now he says.
If that is the
and
case,
the
my
IO
Lord,
says that you have not, then.
my Lord,
whom do we believe?
this signed, my Lord. Am I manufacturing this sign, my Lord? No. My Lord may kindly see the report which has been prepared by the IO, which was forwarded before this honorable court. It was on 4th. And 6th, I have appeared, my Lord. My Lord may peruse the signature of the IO and the signature here, my Lord.
My lord, earlier the submission made was he had appeared on 2nd.
No, my
and
Lord.
The status report was of
That is because of the
4th.
confusion.
Now it's being said it's of that he appeared on 6th. Anyways, the
See,
updated information
Miss Ain,
that he
see, Miss Ain, this, according to the papers that they have produced, the signature, maybe allegedly of the IO, shows the date as 6/9.
my lord.
6/9. So,
Yes.
so if we take this date, so on this date he has appeared for the IO. But
I
if
have
you,
got fresh
but if-
instructions. I've got fresh instructions from the IO on Saturday itself.
Okay.
That these papers, I had sent him these papers. He said these papers were handed over to him by the friend of the accused.
My
And
Lord,
he
my Lord may
never
peruse.
personally-
My Lord, okay, if my learned friend has finished, I will submit.
I think confusion is you say that these papers have been handed over by the
That is the instruction that I have received, my Lord,
by the
my friend.
petitioner.
Yes, my Lord. Yes, my Lord.
But now the IO would say that it is a friend of the petitioner who has handed over.
That is what, my Lord, I have been instructed. Right now also I have been instructed, my
we
Lord. Now, my Lord, if that is the case, my Lord, give me 3 days time, my Lord, I will appear before the IO, my Lord, personally. Again, my Lord. And then, my Lord,
You should have done that.
no, that has been done, my Lord.
Intervening, you should have done that.
My Lord, that has been done, my Lord. My Lord may kindly see, peruse the order of this honorable court, the last order by which my interim bail was granted to me. If I may not
The
produce
order
this,
of the court is on the basis of your submission.
yes, my lord.
If it is found out that you have misled the court,
My lord, I have been instructed,
then-
my lord.
then,
My lord,
you know,
on instruction, my lord, I am submitting, that may be recorded, my lord. On being instructed, my lord, that was if, in case, my lord, taking it, my lord, that I am submitting wrongly, my lord, before this honorable court, then, my lord, IO should not have accepted that letter, my lord, from his friend. How come, my lord, when the letter itself saying, my lord, I presenting myself on so and so date, he should not have received, my lord. If that is the case, my lord, give me only
that is
3 days
also-
time,
That is also a fact.
my lord. Now, my lord, keeping this thing aside, my lord, if there is a confusion, my lord, I am undertaking before this honorable court that I will appear before the IO as a date fixed by this honorable court, my lord. This week itself, my lord.
My lord, there's an updated status report dated 14th September as well that says the same thing. And verbally also I have confirmed from the IO.
If that is the case, my lord, let a date be fixed, my lord. I will appear myself, my lord, before the IO, my lord.
My lord, let him state on affidavit that he has appeared. And if he is found to have misled this honorable court, then action may be taken against him.
Let a date be fixed by this honorable court, my lord. I will appear, my lord, personally.
My lord, but this can't be looked away by this court. The fact
Yes,
that he
yes,
is trying to mislead.
I'm just going through this report.
My lord, second last paragraph, if my lord may come to the received of self-statement from Shri Gopal Krishna Gaur through by hand of Shri Vidnath D. Mara is not enough for my investigation. What more does it?
Yes, Mr.
My lord.
This report, you see.
My lord, what I have been instructed, my lord, that he has appeared, my lord, on 6th. Now, if an IO is taking
Who
it,
is this Vinat?
That is the 14th of September.
This Vinat Dimarat?
That's right, ma'am. He's the one who has handed over
I have
these
no instruction on that, my lord. Who is the gentleman, my lord? My friend is there, my lord, who is briefing me in this matter, my lord. He said that he is not aware, my lord. What I can, my lord, pray before this honorable court, my lord. The hodgepodge which has been created, my lord, that I have not appeared, my lord. But I undertake, my lord, I will appear in a particular date fixed by this honorable court, my lord. Moreover, my lord, may kindly see the order. My learned friend is hitting me back on the order, my lord. Let us see the order, my lord, which has been passed by this honorable court.
Yes.
My lord, the last paragraph, my lord. As prayed for, the petitioner is allowed to go on bail.
Where's the order dated?
Order dated, my lord, 27/8/2024, my lord.
Seven.
27/8/2024, my lord. Order of this honorable court, my lord.
Yes.
Yes, my lord. The last paragraph only, my lord. As prayed for, the petitioner is allowed to go on interim bail under condition that he shall appear before the IO as and when required, and he shall not abscond or tamper with the evidence and witness, my lord. This is not the case, my lord, where, my lord, the IO has summoned me. In fact, it was me who volunteered, my lord. That is the instruction that I have received, my lord. Now, my lord, if the IO is saying I have not appeared, my lord, I am ready to appear, my lord. Just give me 2 days time, my lord. I will appear before the IO, a date fixed by this honorable court, my lord.
My lord, we kindly note that this statement has been made so that, because this cannot be ignored. The fact that the petitioner has tried to mislead this honorable court. This is enough ground to refuse.
Heard Mr. SD, learned counsel for the petitioner, who has submitted that on the strength of this court's order dated 27 8
27/8, my lord.
27/8,
2024.
wherein he was given interim protection on condition that he shall appear before the IO on,
As and when it
as
is.
and when required. Accordingly, the petitioner had appeared before the IO and has also submitted a statement in this regard. I submitted a statement. Where's the date?
On 6/9/2024, my lord.
6/9 or 2/9?
6/6, my lord, is 6/9. The last page, the letter was written on 2nd/9, my lord, but it was received on 6/9, my lord.
What's kunung tungo? Appeared also before the IO on 6/9/2024, duly acknowledged by the IO. Per contra, Ms. S.I. Leonard G. appearing for the state respondent has submitted that the status report filed by the IO, which is produced before the court today, would clearly show that the IO.
My lord, this was on record last time as well, on the last date of hearing as well.
This was already on record.
This was on record on last date of hearing, which was 11th of September. 11th of September we had released.
Filed by the IO, which is already on the records before this court, would clearly show that the IO in his report has stated that the petitioner himself has not appeared before him, and the statement and the self-statement was handed over to him under bracket IO through one Shri Vidnath D. Marak, which has which, according to IO, has caused a delay in the progress of investigation as far as the questioning or interrogation of the petitioner is concerned.
And also, my lord, it is not enough for his investigation, and the physical appearance
that's
is
right.
required.
He said it's not enough.
Well,
So you want those words to be used?
my lord, it's not enough is different from delay.
So I'll rephrase that then.
My lord. Yes.
For which the IO has correct no, submitted that the presentation of the said self-statement by the said Shri Vidnath D. Mark is not enough for the purpose of his investigation. At this juncture, Mr. S.D. Learned Counsel for the petitioner has reiterated that the petitioner has indeed personally appeared before the IO. However, in the face of contradictory statement by on both sides, the person in question, that is the IO, not being personally present in court, this court could not ascertain the actual situation. Mr. SD has then interjected to further submit that if this court so direct, the petitioner would definitely appear for the IO on any date fixed. This court has considered the submission made as well as the materials on record, including the said self-statement filed by the petitioner and also the IO report dated 14 September 2024. Indeed, in the face of claim and counterclaim, the actual situation or the correct facts have not been presented before this court. In the face of such a situation, at this point of time, the court would take a lenient view and direct the petitioner to appear for the IO on
Today is 16th, my lord.
On 19th.
19th of this month.
Failing which necessary orders shall be passed. The appearance of the petitioner before the IO would not in any way affect the decision of this court on the merits of this case, which will for which suitable order will be passed upon hearing the final argument of the parties. This matter, the IO is directed to file his related report on the appearance of the petitioner. This is matter on 24th.
The interim order passed again may continue, my lord.
The interim order pass will continue until further orders.
Item number 10.
My lord,
So
this
all
written
the-
argument, I'm filing it, my lord. On behalf of the petitioner, my lord, I'm filed written argument.
The petitioner has filed a written argument through his learned counsel, Mr. SD. Respondent 7 and 11. As you do respondent, you.
3 to 5.
Respondent 3 to 5 has also filed the said written argument through Mr. Bikram, learned counsel. Similarly, Mr. ML Nokpio, learned counsel for the respondent 7 and 11 has also filed the written argument. So what is you are 6?
MPSC, my lord.
Who's 9 and 10?
No.
Private respondent.
or private respondent, yeah, the expert.
Yes.
Yes,
please,
the
please.
counsel for the respondent 6 has sought for accommodation and has prayed for this court to allow the written argument on behalf of the said respondent within the next day fix. So that is, we are left with your respondent,
Respondent 1 and 2, Lord. 1.
Mr. H. Karmi, learned additional senior GA, appearing for the state respondent 1 and 2, has also sought for time to file the written argument. Who is 9 and 10?
These are the selected candidates.
Selected candidates, my lord.
Private respondent, selected
They have
candidates.
not appeared.
No, they have adopted the submission.
Mr. P. Nambri is appearing.
No, Mr. Joshi, who has
Yes.
who has adopted the submission made by Mr. Nongri and Mr. Harmi.
Yes.
So not required. Accordingly, on premium, this is matter of the 1 week.
Obliged, Lord.
Hello, Mr.
Item number 11.
Your Lordship.
I pray this matter could be taken at the end of the board, Lordship.
Why?
Conducting counsel is on his legs, Lordship.
On his legs?
He was here, he's occupied somewhere else.
As far as I know, no code is functioning except this one.
Yes, Your Lordship.
Only my
If he's on his legs, then
He's
hanging
occupied, he'll be here, Lordship.
somewhere on his legs.
my friend, he's coming. He's coming, my friend.
May it please the Lordship. My Lord, the second appeal has been filed against a judgment passed by First Appellate Court. First Appellate Court, my Lord, being the Court of Additional Deputy Commissioner Shillong. I'll just take a few minutes, my Lord, just to lay out the background of this particular second appeal. Matter, my Lord, arose out of a lease agreement, a lease deed that was executed many years back in 1923, my Lord, between the parties. If Lordship kindly has the paper book.
How many respondents are there?
Just one. Single respondent.
Single.
Yes, my Lord.
Or what about this and another? So and so and another?
My Lord.
Okay.
There are two actually. There are two, but one is the joint Rangbakur, one is the Rangbakur. Both are joint Rangbakurs.
Okay. Please.
My Lord, if Lordship kindly has the paper book, page 14 of the paper book, my Lord, is that 1923 lease deed.
19.
14, 1 4.
Yes.
This was executed, my Lord, on 20th March 1923.
Yes.
If Lordship kindly allows me to highlight a few important aspects from this lease deed. Lordship, on the first page itself, just below the schedule in the middle, the clan after the schedule, my lord, does hereby lease in perpetuity the said land covering an area of 10.19 acres. So the dispute, the suit property is this 10.19 acres, my lord. More or less of upland from 1st April so-and-so to the General Secretary, Sports Section, Shillong Club. It goes on, my lord. If Lordship kindly turns the page 16, subclause H.
Yes.
Subclause H, my lord, I'll read.
Yes. Please.
The lessee shall be entitled to relinquish this lease at any time on giving not less than 1 year's notice to the lessor, his heirs, successors, in interest or assigns. So, my lord, as per this lease deed, that means the lessor, I have been, the lessee, sorry, I have been given the right to relinquish or to cancel or terminate this lease deed. Parallel right of relinquishment or termination has not been granted to the lessee, my lord. That is the second aspect. Second last line on the same page, my lord.
Yes.
The previous lease. The previous lease, which is current until the 31st March 1922, is hereby cancelled. My lord, the date is important. This date, 31st March 1922. So it appears that there was a previous, prior to this 1923 agreement, there was a previous lease deed which was valid up to 31st March 1922. This is significant in view of what I will highlight in some time, my lord. So, my lord, this was in 1923. We got 10.19 acres on the strength of this lease agreement, my lord, of this lease deed. Now, we constructed a golf course on the area. There was absolutely no problem whatsoever. Problems arose, my lord, sometime in 2013. Page 19 may kindly be looked at, my lord.
Page
19, my lord.
Yes.
Page 19 is a letter that we received in 2013, January 2013.
Yes.
The subject may kindly be looked at, my lord. Representation for handing over unutilized portion of the land and enhancement of the rate of land lease rent. So they wanted handing over of what? Of certain portion which they claimed was not being utilized by us. I'll read this letter, my lord. I'll start from the second paragraph below the schedule again, my lord. That the portion of land on the south, as shown and indicated very clearly in the said schedule above.
Mr. General.
Yes, my lord. Yes, my lord.
If you pardon me.
My lord.
Can we take up this matter for 1 week?
Very well. Very well.
Why?
Yes, my lord.
The reason being, I have to clarify, just on these names.
Yes, my lord.
Because at some point of time,
my lord,
no, not in this case.
Okay.
These people were our client.
I see. Okay.
We had appeared for them in some land matters.
Okay.
Me and my senior, of course.
Understood.
So I don't know whether, if that would matter, if not.
To me, it doesn't. I'm sure to my senior also it doesn't, my lord.
We have no objection.
It must have been 20, 30 years back. And just to inform, my lord, this person who has signed this letter, Asishon, thank you, he's no longer alive, my lord.
Exactly. Because I still remember his name.
I see.
He was the Ramakor, of course.
Absolutely, he was. We leave it up to you, Lordship, but we would humbly request that already one honourable court has recused. There should not be any, because Lordship might have appeared at some point.
Yes.
in the past.
20, 30 years ago, my lord. We have no.
I doubt Lordship, with respect, I doubt Lordship will remember what the matter was about also.
No, but if it concerns, you see,
yes, my lord,
those lands, Polo area and this area.
I doubt, because this is a fresh claim.
Thank you clan has got some litigation as far as all those lines, Foot for long and that
True.
area.
So there is some litigation regarding the the bus stand area. That is a different case.
And
Uh,
this is the Laikpo clan.
Laikpo.
They also have a case against the Shikpo clan.
Yes, madam.
There are two sets of clan here.
Yeah, the different clan is there.
Different clan.
I would understand, my lord, if lordship had the occasion to deal with the same dispute here.
No,
I would understand, but
this-
this is recently.
It's a new dispute.
It was filed in 2013, 14. But for my lordship's satisfaction, if lordship want to defer today, my lordship, urgency is there. Is the request from my side and my friends' side also. Urgency is there.
I have no urgency. I leave it up to
Well,
lordship.
since he is claiming
What
and
is
some interim order is there, status quo order, which he claimed it goes in his favor. Even we filed an application for modifying that order. But since commitment has been coming from my side also to expedite the hearing, therefore I did not press. In view of that matter is listed for hearing. Next week.
If lordship wants to apply lordship's mind on this issue and maybe come back next week, very well, my lord.
See, we have to still examine the principle of conferred consent.
If one alternative, my lord, could be that lordship can record in lordship's order that this issue has been highlighted by my lord, and both of us, my lord, have waived any sort of objection on this.
Yes, lordship has even framed the substantive question of law, and none of the party raised any objection.
That was at the
Initial
initial stage. That has to be done in any case before you admit a second appeal. Though again, at that point, I think at the relevant point of time, this matter was not in this court's roster.
No, it wasn't.
Anyway, lordship, we pray for next week.
We'll take it up next week. Though, like you said, you see, if it is a new matter, but then you can never tell. Days.
Today, my lord, is 16th. my lord.
16.
Keep it up on 24th.
24th, man.
Very good. Very good. Finished.
On pre-made parties, this is matter on 24th.
Yeah. Ably obliged.
Item number 12.
May it please the lordship. Lordship, in this item, your lordship, the matter has been put heard, your lordship.
Yes,
Item number 12.
item number 12.
Well, it hasn't been argued yet.
But your lordship, in item number 13, criminal petition number 36 of 23, your lordship, we were supposed to file a written argument, your lordship. We'll be filing it now, your lordship.
But I'm seeking 2 weeks' time to file my written arguments in Act
You
30.
have not filed.
I'm for the petition.
So this is in 13.
Item number 13.
This is in
What about 14?
12 is yet to be argued.
Yes, your lordship.
14 yet to be argued.
Yes, your lordship.
Yes, my lord. 14 is yet to be argued. 12 and 14 are yet to be argued.
15, my lord, I'm seeking some more time, my lord. Some difficulties, my lord, it couldn't be finalized, my lord. We were supposed to file those, my lord, compilations.
But the issues more or less would be the same.
Similar, my lord.
Because it comes out of same proceeding.
Same proceeding, my lord.
And if I'm made to understand the same order.
Same order, my lord, but the rule will be different.
Yeah, of course, the rule.
Yes, my lord.
A2, A3, A1, all those.
Yes, my lord. Otherwise, other aspects, my lord, it's same, my lord.
This is the problem. See, I don't know why this matter is taking so long. If I recall, I've heard the learned senior counsel, Mr. Khurshid, in this matter. I think, I don't know, was it 2 years ago?
Not 2 years, my lord. Something or the other, my lord, came up in between for that reason, my lord. Otherwise,
unnecessarily, we are delaying the matter. So, what about 12?
12, Lordship, if item number 13 has been decided, Your Lordship, it will have a bearing on the other items as well, Your Lordship.
On all the other.
If 13 is decided in our favor, my lord, then the rest may, 12 may not be. Worship.
Yes, yes. This is against the order of framing of charge.
That's it.
And the other, I think one, who's appearing for A3? In which case? 14 and 15. 14 and 15. What is the impugn order hearing?
This is against severance of trial.
Severance.
Since
Yes,
there,
I understand.
of the
A3.
A3.
Okay. Who is said to be on sound mind and so on so forth, whatever. Okay. Okay, that is also A3. Okay.
Item number 12 will have bearing, my lord. After this, this matter is decided, my lord. So automatically that also becomes, my lord, in practice.
If
it is decided in our favor, my lord.
So if the trials court order is is allowed to stand, the proceeding will continue, and all the other case will have no bearing. Presumably, I don't know. I'll have to go through the effect.
My lord, you kindly grant me 2 weeks' time on the petitioner in item number 13, my lord.
Item number 13, Mr. Guru has submitted that the written argument on behalf of the petitioner and behalf of the respondent has been filed today. Ms. S. and Leonard, counsel appearing for this petitioner, has sought for 2 weeks' time to file the written argument on behalf of the petitioner. Reallowed. So we'll list all these matter up to 2 weeks then.
Up to 2 weeks, my lord.
12,
16, Your Lordship.
This is matter up to 2 weeks. Then you get 12, 14, 15, 16 on pre-made by parties. This is matter up to 2 weeks.
Much obliged, Lordship.
Obliged.